My name is Professor Boni Meyersfeld. I'm a professor at Wits School of Law. And I'd like to talk to you about a story that happened maybe 6 or so years ago in Paris. There was a meeting between a number of marketing organizations. The highest level of those organizations were sitting around the boardroom table having a discussion, who knows about what. Most of the people in that room were men. There was one woman. And towards the end of the meeting, one of the CEOs of one of the companies passed lewd comments to the woman in question. She wasn't employed in his company. They operated in different parts of the industry. But she nonetheless wrote an article in which she leveraged off the hashtag #MeToo movement, cited and explained the incident, and instead of saying hashtag #MeToo, coined the new phrase hashtag #NameYourPig, which sounds a lot better in French, and I won't dare insult an entire nation by trying to phrase it. He sued her and Facebook, which is where she had written the post, for millions and millions of euros. Over the period of 5 years or so, this case went through the courts. In the first 2 rounds, he won. Massive damages claim against Facebook, and an even bigger award against this individual woman. His claim was that by publicizing what he had said, by stating publicly what he had said, by creating this hashtag of #NameYourPig, she had brought his reputation into disrepute. And so you have this classic tension arise. On the one hand, every person has the right to a dignity and their good reputation. Also have the right to privacy. On the other hand, we have the right to speak freely, to say what we want to say. Add into that mix the problem of gender-based violence, which is, as most people know, one of the constant, persistent, unwavering, and culturally irrelevant human rights violations in the world, where 1 in 3 women worldwide have been or will be subject to some form of gender-based violence, and where in South Africa 1 in 3 women are raped. And so this particular case brought this tension into focus globally. The Supreme Court, the French Court of Appeal, ultimately found in favor of the speaker, of the woman. And part of their finding was, well, she's speaking about gender-based violence that happened to her, and even though it was a comment, there was an understanding that when a person in a professional world speaks to you in that way, when you move from what you think is a professional engagement where you're talking as equals, when suddenly you are no longer perceived, you realize you're no longer being perceived as a professional person, but as a subject, as a woman, and as an object. And suddenly you're vulnerable. That space you're no longer in. And the court understood this. We have the same problem in South Africa. Increasingly, women are naming their perpetrators online. So why do they do this? Well, in many instances, people say, well, you must go to court and you must get a court order that finds him guilty. Otherwise, you can't name him. They use public perception is that you have to use, you've got to be proven guilty before you can be named like this. Otherwise, you're innocent. But we have a problem, particularly in South Africa, but it's not unique to South Africa. And the problem is that actually there are almost no legal remedies for women who are raped. Yep, no legal remedies. Why do I say this? Because at every moment of engaging with the legal system, there are barriers for victims and survivors of gender-based violence. So let's assume that after a person is raped, let's assume that she has the presence of mind to even realize what she's experienced. Let's assume that she has the support. Let's assume that she has the wherewithal to actually go to the police. The majority of police are either deficiently trained or are so themselves traumatized through secondary trauma that they are not going to display the empathy, certainly not the understanding. But you're given a piece of paper and make your statement, write your statement. It's assuming a person is literate, it's assuming a person is able to do so. And let's assume that happens. Sometimes the police will write the statement as you describe it, and it'll have nothing to do with what you've actually said. Or sometimes they'll say, listen, he was your boyfriend, go back. Or they'll say, were you drinking? Or they'll say, what were you wearing? Or they'll say, we know you're going to withdraw the case, we're not interested. And let's assume that the police report is filed successfully, and let's assume that there is a decent investigating officer assigned to that case, and let's assume that that case has an investigating officer that doesn't change 3 or 4 times within a year. And let's assume that that investigating officer is able to engage properly with the victim and understand that maybe the victim's statement will change over time as more and more of the details come back to her. And let's assume that the investigating officer creates a report that is ultimately a viable docket that goes to the prosecutor. And let's assume that the prosecutor decides to take on the case, because most prosecutors are correctly interested in a winnable case. And we know that rape cases are not winnable cases. And let's assume that the prosecutor agrees to prosecute the case. And let's assume that the docket doesn't go missing. And let's assume that for the first hearing, the defendant actually, or the accused actually turns up. And let's assume that there are not 4, 5, 6 postponements of the matter over a period of 3 years each time the victim has to come into court, each time she has to see the perpetrator, each time she has to relive what it is. And let's assume that ultimately when she's on the stand and has to testify, and because you must remember, she is not the client, she is not the complainant, she is not the one suing this man, it is the state. She is a mere witness. And let's assume that on the stand the prosecutor knows how to manage the process, and let's assume that the prosecutor is able to get the relevant information out of her. We then have another problem, and this is the law of evidence. Right? So the law of evidence says, how does a judge determine if a person is telling the truth? And one of the things that a judge must take into account is, how believable is the witness? Do they look you in the eye? Or do they mumble? Are they clear? Do they remember specific things? Are they able to be coherent? Are they sufficiently confident? Do they make any contradictions? Add to that another problem, and that is, if you're a single witness, the law of evidence says, we've got to take your evidence with a pinch of salt. That's a colloquialism. The principle being that a single witness can make anything up. And bear in mind that these laws of evidence have a history that goes back well over 100 years. In fact, it was only until the 1980s that we had a very, very unbelievably harmful principle of evidence law, the law of evidence. And this was the following. Where a woman claims that she has been raped, the court must treat her testimony with great caution. It's called the cautionary principle. And why must they treat it with caution? You can go back and look at some of the judgments, and they quite, the hair will raise on the back of your neck, because women have a tendency to lie, because women are duplicitous, because women claim rape when they've fallen pregnant, because women claim rape when they have been ditched by their boyfriend, that they consent and then change their mind, that they're trying to ruin the reputation of the man, that women therefore are not believable, and so you must be very cautious when listening to them. That is, or that was, a principle of law. And while that law has actually been set aside, the spirit of that law has not. And so we continue to see today in the courts, yes, but what were you wearing, says the judge. Why does that matter? Yes, but were you drinking, says the judge. Well, the real question was he drinking. The real question was, did he know that she was drinking? And you see that the judge is not only carrying this heritage of sexist cautionary rule, but it is imbued with power today under the principles of the law of evidence to actually say, but you're not being very coherent. Now, why is it that victims of rape often are not coherent? Well, the answer is a very scientific biological answer, and that relates to neuroscience, neurology. So the brain's an amazing thing, and most lawyers, certainly not me, don't know much about the brain. But in the work that I've been doing, I've come to understand the following. When you're faced with trauma, or when you're faced with danger, most people know about the fight and flight reactions, right? A lion's coming running towards you, you either stand your ground and fight, or you flee. It's an automatic reaction. It's not that you make a choice. Your brain calibrates that danger. Your brain calibrates the options around you, and it makes a decision. It's a remarkable, remarkable thing. There's a third response though, and that is called fright or freeze. In certain instances, you know that you're not going to be able to fight, you can't get out, so you freeze. In the 1990s, I think it was, the European Court on Human Rights first articulated the notion of frozen rape. In that case, a woman had been raped by two men in a car, violently, brutally raped. And the court in the country's court had said, you didn't fight back, you didn't say no, you didn't scratch, so you must have consented. And it went through the appeal process up to the regional court, the European Court of Human Rights, where the judges understood that actually she knew she couldn't fight two men pinning her down. She certainly couldn't flee, she couldn't get out of the car. So her brain put her into something called frozen fright. And the idea there is that your brain protects you as much as possible in that moment. Part of the protection is it shuts off your consciousness. And it's often I equate it to a situation if you've been in a car accident, for example. And a lot of people won't remember all the details, right? You don't remember exactly what happened moment by moment. You might remember a sound, a screech, or the crash. You might remember a smell. You might remember a color. But you won't necessarily remember all the details. The more traumatic the incident, the greater the brain shuts down, the less you remember. And over time, more and more will come back to you as your brain's defense slowly moves away. In fact, we see that all the time with child abuse, right? It can take 20, 30 years before the person remembers, actually, I was abused as a child. And the same thing happens with rape. Now, how does that work with the law? Appallingly. Remember our policeman who says, let me take your statement? She says, I was raped. By whom? I can't remember. Or she can remember, where did it happen? I can't remember. Or she says, I think it was at 2 o'clock in the afternoon. Fast forward 3 months with the investigating officer takes over, and now she's remembered actually it wasn't 2 o'clock in the afternoon, it was 5 o'clock in the evening. And he says, but why is there a contradiction? Are you telling the truth? Fast forward to the actual case, the trial, where all of this is before the judge. The judge who already treats this witness with caution. The judge who, and while I don't wish to paint the judiciary with the same brush, absolutely not. The reality is that most judges don't appreciate the neurological response of rape and will simply say, but why the inconsistencies? Rules of evidence allow me to determine your believability based on whether there are inconsistencies. I therefore don't believe you. Or a woman who's been raped who must come into a courtroom where more often than not the majority of the people in that courtroom are men, and she must talk about what happened to her, and she must talk about it openly and clearly and articulate it, and she must bring to this discussion confidence, accuracy, specificity. No. Mostly what happens is there'll be slow speech. Very difficult to look people in the eye when you're talking about something so traumatic. And so all of the benchmarks of what makes a good witness often don't apply in rape trials. And that is why, based on research in which I was involved in, I think about 2016, we found that of all the rapes reported in South Africa, and statistically only half of rapes reported, only half of the rapes that occur in South Africa are actually reported. Of those, only 8% result in a conviction. And that's before an appeal. So if somebody comes to me and says, I've been raped, what can I do? There's very little chance that my advice will be, let's go to the police. Not because of the police, not because of the investigating, not because of the prosecutor, not because of the judge, but because of the system. And there are amazing people in those systems, don't get me wrong. But there is too much inherent in the system that precludes justice for women. So now let's circle back to name your pig. And in South Africa, women start naming their pigs, their rapists. And they name and identify their rapists for a number of reasons. Some work done by the Women's Legal Centre in Cape Town, a remarkable NGO that does an enormous amount of this work, plus other gender-based violence work. They started to see that women would name their perpetrators never because they wanted revenge, never. No woman came in and said, I wanted revenge. For the majority it was, I wanted to speak my truth. I wanted to say what happened to me. Or I knew he had done it to other people and I wanted to warn other women. That's a big one. Or I'm dying inside. I'm dying and he's been celebrated. And the world needs to know that this is what happens. Or I need to be able to show other women that we can be brave and speak out. Or I need to know that there's some form of accountability. And so I'm going to identify this person. It is never because she's bitter that he had broken up with her. It's never because she's pregnant, and it's never because she wants revenge. In response to these public namings, many men have resorted to defamation law, like the one that we saw in Paris. You've compromised my reputation, and I won't go into the law of defamation, but that's really scary stuff. And in fact, until recently, we had something called criminal defamation, where I could actually open a criminal complaint against you for defaming me, and men were using that to open a complaint to report this woman to the police for defaming him by saying that he had raped her, and suddenly she would be part of a criminal trial as the accused. Thankfully, that's been revoked and we no longer have criminal defamation. But in South Africa, men are also turning to other pieces of legislation to ameliorate the publication of their conduct. And in particular, they're turning to two pieces of legislation. The one is the Protection from Harassment Act, and the other is the Domestic Violence Act. Both of these acts are part of a suite of legislation that was developed throughout the 1990s, 2000s, to protect women from gender-based violence. It's not the only purpose, but it's the predominant purpose. So men are taking out protection orders. They're going to court, to magistrates, and saying, listen, she is posting or has posted this. I am terribly hurt. My girlfriend is terribly hurt. My business is being compromised. She is causing me distress. I've got to go see a therapist. And I need a protection order against her to make it stop. And the magistrates are handing these out. So they making protection orders, and again, it's not all magistrates. It really isn't. But it's the system that allows magistrates to do this, and it's the majority. And they are handing out orders that say she has to remove that post. She has to pay him. She has to be silent. And in one case the magistrate had said she is prohibited from ever talking about any rape, irrespective of whom, again. Technically, she couldn't even consult with her lawyers. Thankfully, we had that judgment, that protection order overturned. So the result is, you have this legislation that's supposed to help victims and survivors of gender-based violence being used against them to silence them. And silencing women is the very thing that South Africa is trying to undo. Right? Everyone's speak about gender-based violence. Let's talk about gender-based violence. Let's break the silence. Right? The Constitutional Court several times has said we must understand that there is an imposition, a gagging of women and children and everybody who's been a victim of gender-based violence or sexual violence, that we must stop that silence. We must talk about it. And here, this legislation is gagging women. So it's antithetical to the purpose of the legislation, to the country's movement, to the presidential proclamations. It is an inversion, an appropriation of something that was supposed to help women now to harm them. And in one particular case, again in which I was involved, in the case that I wrote a piece about, the decision, or the court had to determine whether what she had done was harassment. Did it constitute harassment? And here's what she had done. She had been raped by a writer. They were all part of the writer art scene, literature scene, very, very respected author. He had raped her. They dated for a while and then he raped her. And she complained to 3 organizational bodies. The one was a university body, the other was a literary body, and the third was a body involved in the organization of a particular festival. She said, I am scared. He's going to be at this festival. Please help me. Please protect me. I am scared. Not a single one of them did anything. There was no consequence. Based on those reports, he obtained a protection order against her under the Protection from Harassment Act. That she was not allowed to speak about it, that she was no longer allowed to say anything, and that she had to issue an apology. She had to revoke the post, and she had revoke all of the complaints and issue an apology to him. And as usual, it wasn't just her. She was in fact joined by another woman whom he had raped. He didn't bring an application against her, and we don't know why, but 2 people have now gone through 3 disciplinary processes, organizational process, to say, I'm scared, nothing has happened, and now she's silenced. And in the appeal, the question really was, has she harassed him? And the court had to grapple with this notion of harassment, because also men should be able to use that legislation. It is possible that men will be harassed by women, by other men. This is not a focused, it shouldn't be available only to one sex or gender. That's not the world in which we live, nor should it be. But should it be appropriated or misappropriated, to cause a barrier to the very justice that act is supposed to offer. And so the court said, look, in order for it to be harassment, it must pass a number of definitional requirements. And even if it does pass a number of definitional requirements, and you can say, yes, it is harassment, there's an additional question, which is it in the public interest? And the court went through each of those requirements and found, with some question mark about one of the definitions, found that let's assume that it was harassment as per the definition of the Act. But the court went further and said, but it's in the interest of justice that she did that. And it said we live in a country in which we have to speak about gender-based violence, and we live in a country in which women are terrified to walk at night. And it sounds so trite. It really does, because we've said it so many times before. But every time a woman walks down the corridor in her residence at a university, she might be raped. Right? If you're sitting at your desk in your office and somebody walks into your office and closes the door, you can't get around them, and so you start thinking about, where am I going to put my desk in my office? And you can be working late at night in a financial institution, and this is a true story, working for 3-4 months as the favored new upcoming banking authority, a woman who had graduated with honors from South Africa, got her master's from Harvard in finance, came back to this excellent bank, started doing this amazing work, was completely mentored by the senior man in the specialization which she worked. And one day, as they're working late at night, he puts his hand on her leg and says, I don't know how much longer I can control myself. And her world just collapses. And she says, I've got a terrible headache, I've got to leave. And she's terrified. And then a few days later, she reports it to the human resources. And the human resources policy is, this is what you've got to do. You've got to ask him, and then you've got to then take certain steps. So they ask him, and he says, look, it's actually been a bit of a problem. She's not very good at the work. And she doesn't want to work late. She's a bit lazy. And I reckon that because I've been talking to her about this, I think this is what she's trying to do. She's trying to undermine us. And he then ices her out of the work. He won't bring her into any of the meetings. He won't let her work on any of the projects. And suddenly she is, in fact, out in the cold. And eventually she leaves because nothing else is being done. But then she finds she can't get a job at any of the other financial institutions because he's told everybody, watch out for this person. And 11 years later, a woman, black woman, so fighting against every single barrier to get where she did with a Harvard degree, can't get a job in the financial sector. So do you want to go through a complaint? And so now let's circle back to this woman who is technically has harassed this man, and the court says, no, it is in the public interests. And it's not that you can always say anything at any time, but you have a right to speak. And you don't have to first go to court and prove that he is guilty, because we've already established 8%. Court's not going to do it. We've already established this. Not even reporting it. It's going to cause so many people more harm than good. And you know how many lawyers there are that specialize in direct legal services for gender-based violence? Maybe 20 across the country. And this is the reality that we live in today. So should a person be able to speak? Yes. Should a person be able to warn? Yes. But then you have Donald Trump, irrespective of your views politically, and a former, maybe he's not, but a very senior journalist for the New York Times, both standing up and saying this is the most dangerous time to be a man. And this is coming from a man who has already on film spoken about how he has violated women. And so let's circle back then to the harassment case, right? Where the assumption is so often that women are lying, and there are false complaints, absolutely. But depending on the statistics that you choose, it's anywhere between 3 and 7% globally. So it's infinitesimal, but the airtime that false complaints gets is so disproportionate to its occurrence that one has to wonder what's driving it. And in my experience, with over 25 years of working in these issues, I've never once come across a false complaint. And what is a false complaint? Is it when she withdraws the case because suddenly it's just too hard because it's been the 6th postponement and she can't anymore? Or is it where there's evidence? Or is it where she says, I'm sorry, I didn't mean it, because she's been brutalized into withdrawing? And what the court has done in this case, for the first time, has brought together the reality of our world, the laws, and started to make a change to the system that's supposed to assist. And there's every hope that as this type of jurisprudence, these judgments, can create a broader environment in which women can talk, men can talk, people can talk, and say, I was hurt by this person, because why should they not? And while we always need that balance between the right to privacy and dignity and the right to speak, we must remember that 1/3 of women in this country are raped. There's not only 1 or 2 men who are doing it. And this is the reality that the law must respond to.